I don't know that everyone in the room knows, but we're certainly going to miss you in Atlanta. But in your new role, we'll just continue to pound your cell phone when we have problems. So let's go ahead and
going to keep right on working on this. But Doug Jenkins, Georgia Power. In the last meeting, I was our Metro North Region Director, kind of working up in the Gwinnett, North Fulton area, but I am moving down to Columbus and going to be our West Region Vice President, kind of running our operations for the western side of the state, kind of roam down through that particular area all the way down through Valdosta. So looking forward to that, but we'll also continue to work on criminal justice and a lot of other issues for Georgia Power and Southern Company. Thank you.
Good afternoon. My name is Ed Harbison, and I'm just honored and glad to have a new neighbor moving to Columbus, Georgia, because he has the power, and I know who to call when they try to put my lights on. So we're just glad to be here. I represent Columbus, Georgia. I have 7 counties: Macon, Marion, Taylor, Talbot, Schley counties. And I've been in the General Assembly for 29 years. I serve currently as chair of the State Institutions and Property and vice chair of the Veterans, Military, and Homeland Security Committee. Just glad to be here. Thank you. Sure.
Good morning, everyone, or I guess I should say afternoon now. I am the secretary, I guess, or admin for this task force. So if you have any questions, concerns, or need anything following the meeting, my name is Jenna Does. Thank you.
Senator
Chuck Payne, I'm state senator for the 54th district, which is Whitfield, Murray, Pickens, and Gordon up in Northwest Georgia. Been in the Senate for 5 years. Before that, I was 30 years. I was a caseworker. I'm a rare bird that there weren't many of us that were actual caseworkers for 30 years with the Department of Juvenile Justice, but I had no desire to be an administrator. I just always, my passion was working with kids and trying to through the courts. And so that's why I hope we can do well on this committee here.
I know Tim just took a bite, but maybe we'll jump right here and then we'll come back to Tim. Let's go ahead and get started with you.
Thank you, Mr. Chairman. Mr. Chairman was a panel full of chairmen. So thank you. My name is George Ray. I'm a attorney with Nelson Mullins here in Atlanta, and I'm pleased today to be here as a policy consultant with the Georgia Justice Project. And we've got a whole team from there that I'll let them introduce themselves, or if Brenda wants to take the lead. Let's go. We'll get on the line.
All right, we'll go right down the line. So good afternoon, everyone. Thank you, Chairman, for having us. My name is Wade Askew. I'm an attorney at Georgia Justice Project. I'm one of the newest members of our team. So I'm happy to be meeting all of you. Thanks for having us. I'll be splitting time at Georgia Justice Project between doing some work here on the policy front and also doing our reentry legal work.
Hi, everyone. I'm Brenda Smeaton. I'm the legal director at Georgia Justice Project. Hi, I'm Rachel Holmes. I'm managing attorney of our criminal defense team at the Georgia Justice Project.
Tim?
So my name is Timothy Head, and I'm the executive director of the Faith and Freedom Coalition, which is a national organization that happens to be based here in town. So I'm just north of town. Happy to be able to chip in a little bit here on what issues.
You can't hide from us.
All right. Georgia Justice Project.
Lewis? Just gonna wave. We have with us today Louis DeRue, who is the Bartow County GOP chairman, but he also is a chairman of my campaign. As we travel the state, many of you have seen the 2-lane travel to become running for the office of Labor Commissioner. Next to him, we have Hannah Harding, who is our Chief Development Officer in my companies as well as on our campaign. And so a lot of the social media you hear, see, a lot of the communication goes on, comms comes through her. I saw Zach back there somewhere, but he may have decided to escape. Our Commissioner Oliver was not able to be with us, but Zach was here helping us as well, try and pull some information together from the prison systems. Kind of as a recap, as many of you know, in our last meeting, we were able to craft some legislation that came about as SB 105. Is step back before that, the whole reason we came together, morning, was we wanted to explore what our state looked like when it came to systemic racial inequality. And really 3 people, myself, Tim, and Lisa McGahan, talked about what this might look like and could we do some meaningful legislation that would affect not just one population, but the entire population. it's interesting how that now ties into where we went with the pandemic and now we have labor issues. And so we started with labor issues before the pandemic. Now we're after the pandemic. And I would say even more, as we talked, George, briefly about what this looks like as people try and get back to work and we continue to try and drive an economy. SB 105, we were able to have signed into law by the governor. And if we can just get an update, kind of how that is being administrated and what the thoughts are around that before we move into other things. So we'll call that old business, so to speak. Please.
Absolutely. So as you're aware, it was signed into law on May 3rd. By July 1st, Department of Community Supervision had done a rollout where they were then able to start reviewing old cases that were eligible for early termination. So they had started that process on July 1st and we're reacting retroactively. As of recently, they have been able to implement the criteria into their system. So they're now really pushing out the petitions for early termination. So they have completely been able to rework their system so they can look at it. So a probation officer can look at a case to see if they're eligible for early termination. They don't have any data yet, but they're hoping to have it by early November of actually how many petitions have been sent. But we're obviously very aware of a lot that have been sent. At GJP, we have done several webinars for directly impacted individuals and have done presentations for hundreds of individuals about whether or not they're eligible for early termination. And we also host listening sessions the last Friday or last Wednesday of every month for those individuals that are eligible for early termination, but have hit some type of roadblock and trying to figure out what that is. And then we are meeting monthly with DCS to kind of go over some of those roadblocks so DCS can figure it out from them so we can really figure out if there's any issues in implementation. And so far, we have not run into a lot of those issues. It seems that we have been able to push through. Almost every individual that we're aware of that we've talked to DCS has had a petition sent. So I know that DCS has done a lot of training on their side. And the chief probation officers for every county is meeting with the chief judges. So to talk more about SB 105 and make sure there's a process in the court system for them to move through that. I would like to tell one story. I'm sure everybody that was involved in SB 105, we had one of our, somebody that we're working with, his name was Mr. Child, who actually testified at a committee hearing last year, and he was eligible for under SB 105. And he, a probation officer, submitted his early termination petition, and we actually had a hearing, and the judge granted it. So he was able to get off of probation. He graduated in July with an accounting degree, and he's studying to get his CPA, and being able to get off of probation has allowed him to get a job. He's actually also been able to buy a house. And something that I thought was extremely moving at his hearing is that the victim in this case showed up. And by the end of the hearing, they were shaking hands and were saying best wishes to each other. So it was I think it was a very healing moment in all, which I think we're hoping for at the end of these probation sentences for people to be able to heal, and as well as the victim was able to heal finally as well for this case really to be put behind everybody.
That's awesome. Thank you for that. We also have an update on the other bill that we have currently in the House, right?
Oh, the one that it was a couple years older.
Yes.
288. Yeah. So
And then 186, I believe. Is that right?
we can talk about it as we go through it.
Okay.
That's all right.
All right, sure.
Well, first of all, thank you, Mr. Chairman. Welcome, Senator Anderson. He just came in just minutes ago. Let's talk just quickly, I guess. Brenda, if you want to give an update on Senate Bill 288 and how that implementation is occurring with our work.
Sure. So that bill does precede the work of this committee, but there's a lot of overlap. Of course, Senator Anderson was the sponsor of that bill, and Senator Payne spoke in favor of it, and we worked with Houston Gaines over in the House, and that passed in 2020, but it didn't go into effect until this January. And just a reminder of what it does, it's the first time that Georgia has really recognized rehabilitation through our ability to clear records. It used to be the case that you could only get non-convictions off of your record, leaving us way behind over 40 other states that allow somebody to demonstrate their rehabilitation.
So the law that was passed, drafted by Senator Anderson, what it does for individuals who have a criminal history is you can potentially get up to 2, it's a lifetime minimum or a lifetime max, but up to 2 misdemeanor convictions restricted and sealed from your record, which is what we call expungement here. And if you received a pardon for a felony conviction, you can ask the judge also to restrict and seal the record of that conviction, so it won't inhibit your ability to get employment or find a place to live, and that you can move on with your life and be self-sufficient. Also, the second part of that bill, and perhaps hopefully even more influential, is what it does for employers. We work closely with the Metro Atlanta Chamber of Commerce, and we're able to draft some language that I think makes us one of the strongest states for liability protection for employers who engage in second chance hiring. So what it does is it limits the liability of employers if they hire somebody who's had their record sealed, or who has received a pardon, or who had an arrest on their record but wasn't convicted. So lots of folks eligible. As you know, 4.3 million people in Georgia have some kind of criminal history. Our minimum number of people that are eligible, and it is a petition-based process, so all those folks have to apply. But about 1.5 million folks have either 1 or 2 misdemeanor conviction, so they could potentially clear their record through this. And just to give one example, one way that we're trying to implement this law and make sure everybody knows about it is through our first second chance desk that we opened up in Cobb County, and has been going since about June. We go up there every Friday. So that's a partnership with the prosecutors and the judges up there. We're able to get people through quickly. And I spoke to a client last week who, his name is Aaron. He's 28 years old, came in with his 2 lovely kids. When he was 19, within like a month of each other, he got 2 misdemeanor shoplifting convictions. And he is in school at the Aviation Institute of Maintenance. He's going to graduate in January. He's tried to get on at some airlines, and he's been denied because of those convictions that are 8 years old. So we were able to completely clear his record. So hopefully that will not inhibit him after he graduates. And he just, we meet with about 8 to 10 people a week, and usually 3 to 5 of them were able to get a conviction off of their record each week.
And a big shout out to Barry Morgan up there for being able to engage in that and make that happen. So
Yeah, absolutely. Yeah.
Right.
So that's SB 288. And the other thing we're doing, is trying to get the word out to employers. We've been hearing from a lot of employers, more than we ever have before, because of this labor shortage, about, how do we engage in second chance hiring. Just came from a meeting with the Georgia Chamber of Commerce, looking to do some education of their members together, and continuing to try to work on that.
And just to close out the old business here,
Yes,
I
sir.
want to direct you. You should each have a folder with the Georgia Justice Project logo on it, but there are 2 handouts I'll just point out to you. One is front and back that really gives an overview of 105 and 288 and how they're being implemented. And then a second that talks a little bit more about second chance hiring generally. So those are for your use and for your education. We're happy to talk more about that as we get going.
So let's stay at 105 for just a second. Again, we don't have data, right? It's difficult, but we do have practical application, as you've talked about. Anything that we see right now that's bubbling up that we may need to adjust or massage or make some amendments to as we see that being implemented to the committee, but specifically to Georgia Justice Project. Sometimes it's easier when it's first being implemented than it is once it's rolled completely out, but
I would say this time we haven't really seen that happening. I think there is, and it's difficult because we're still so early on into it, because I think part of the issues that we're having is scheduling of having the hearings happening on a regular basis. But we all know that there's such a backlog, right? Because of pandemic, that is kind of hard to figure out where that's fitting in. And really what we're trying to focus on now is education, to see if that can be changed prior to doing anything outside of that right now. But that seems to be the biggest, is just getting it through the system, because there is such a backlog, and it's a process. Like, you have to file a petition, and then there might be a hearing, and that's just a process that's happening. So.
do we have interaction with those on Zoom? Are there any questions? Do we have any comments for anyone from? We're opening this up right now to some of you that are participating on Zoom. I know Senator Strickland, Karen Shack, and others are on Zoom if there's any comments or questions from them.
No, just thank you. This is our Karen
Hearing
Check.
none, I
Thank
guess
you.
we'll keep moving. All right, so we'll move off of SB 105, George, and if you want to continue.
Sure.
Okay, down that.
Sure. No, thank you, Mr. Chairman. And we'll hop over to the deck now if it's working on. Okay, perfect.
There's a clicker.
Okay,
back
I'll
there
grab that.
on the podium. If you wanna- Okay. It's not showing.
Talk and click. That's probably better. Okay, so thank you, Mr. Chairman. We're excited to be here with you today, obviously, and talk about what we've worked with you together on, and also think about what we're looking at going forward. And as Georgia Justice Project, as we think about policy that is informed by the work of that we're doing in the field, directly serving clients, we're focused on getting Georgians back to work. And that's really at the name of the game and why it's so important for us to have this conversation. We appreciate the opportunity to do that. So what we'd like to do is step back for just a second, because I know we see you a lot during session, but we're all coming back from the summer and figuring out who everybody is and what's going on. I would love for Brenda to give a quick just overview of GJP and lead us into our conversation about how we get to our policy recommendations.
I will be very brief because I know you're very familiar with the organization through Lisa, and you see how many of us it takes to replace Lisa. So she sends her greetings. But we're a legal nonprofit. We've been around for 35 years. And for most of that time, we just did direct service, and direct service is still our driving reason to be here, and drives all of our policy work. So all of our work, both the direct service, the education, and the policy work, has two goals. One, reducing the number of Georgians who are under correctional control, and two, reducing barriers to reentry for those who have had some sort of interaction with the criminal justice system. The ways that we continue to do that is through our core service, going back to those 35 years, is through holistic defense, meaning our attorneys pair up with social workers, and that is something that we do in Metro Atlanta, take on a number of criminal cases a year. Representing folks that are interested in making a change and actively participating in improving their lives with our social workers. And also we visit our clients if they are convicted and they go to prison, and have social workers to ease them and help them with reentry. About 15 years ago, we started doing the criminal records work, which has really by volume become the largest part of our work. We represent about 300 to 400 people a year in cleaning up their criminal record. We utilize about 150 volunteers, mostly firm attorneys and corporate attorneys who help out with that. And soon after we started doing that work is when we got involved in the policy. And as George said, all of our policy is really grounded in what we are seeing every day with our clients through that representation. And I think Wade will talk about that a little bit more and how it specifically informs some of the policy goals that we're going to talk about. But we ask all of the people that come to apply for services why they're there and what is their major concern. And by and large, for most of them, it is employment. Even in this market where it is an employee's market, they want to get a job that has a living wage. They want to be able to move up in their job. They want to be able to get a job with benefits. And sometimes they can get those entry-level jobs with a background, but they can't go any further and they can't support their family. So our whole campaign is about helping those folks that want to help themselves and be self-sufficient.
So I know we've finished with old business, but we would be remiss if we don't stop for a minute, come back and say thank you for the work that Senate has done, the General Assembly has done, Governor Kemp has done in the last couple of years, beginning with Senate Bill 288 authored by Senator Anderson, which really opened up opportunities for criminal record restriction and sealing in Georgia. We're seeing that begin to pay dividends and have fruits as Brenda has talked about. And then also for Senate Bill 105 last year that was heralded by this task force and led by Senator Strickland and through the Senate and through the House. That's again getting to work as well. So thank you to this group. Thank you to the General Assembly generally and to Governor Kemp for supporting these efforts as our old business wraps up. So as we think about those efforts, getting Georgians back to work, we think about, okay, what's next for helping getting Georgians back to work? We think about our policy going forward, particularly in the coming year, as sort of fitting in three buckets. How can we address these issues in three big buckets? First, driver's license. We'll talk a little bit more about stats, but to work in Georgia, frankly, you need a driver's license. So figuring out ways to make sure we limit the number of suspensions and make those suspensions less costly is key to getting more Georgians back to work. Second bucket we'll talk about is occupational licensing and how we open the doors to occupational licensing, which is large and many times a gateway to a good paying job. How do we get folks who have re-entered society, who have rehabilitated, to be able to get those licenses so they can get those high paying and high demand jobs? And then third, talking a little bit about building on Senate Bill 288 and expanding access to expungement, because as Brenda said, we're getting into some of that work, but we're also seeing some of the challenges that are being faced, even given that legislation. So we'll talk about a little bit of the problem in each of these three buckets, and then talk about some proposed solutions, and of course, invite questions throughout as they come up. So jumping right in, let's talk about driver's license. So I've got 4 stats, and you have a copy of this presentation in your materials as well. So feel free to pull out, take notes. The font may be a little bit jumbled here, so it may be easier to read in the version. Yeah. So please refer to that if it's unclear on the screen. So just want to highlight 4 quick stats that really exemplify the problem around driver's license. One that I've already hit on, that is almost 80% of jobs in Georgia require a driver's license to get to or from. It essentially requires a license in Georgia to work. Yet still over 105,000 driver's licenses are automatically suspended each year for failures to appear. So how that happens is individuals get traffic tickets, essentially. They don't get to court either because they have employment issues, they have payment issues, they can't pay the ticket, they have childcare. There are a number of issues that keep you from getting to court. Automatically, Georgia law requires that license be suspended. And that license cannot be reinstated until the ticket is fully adjudicated and fines are paid. So tons of licenses are suspended every year without discretion, without any action by the court. Third, and this is really a striking figure where it really hits home. Almost half of people who lose their licenses lose their jobs. And you really begin a cycle there because, okay, you lose your license, you lose your ability to get to work, so you lose your job. Okay, you lose your ability to make money to pay the fine and get your license back. So it really starts a vicious cycle, and that is a real highlight of that. And then finally, to a state stewardship point, 50,000 Georgians annually are arrested on driving on suspended licenses. So there are people who have to go to work. I mean, if you lose your license, you still have to go to work, and you risk it every time with getting pulled over and getting arrested for driving on a suspended license, even for traffic offenses that didn't originally result in couldn't result in a suspended license. Just because you didn't show up to take care of the ticket, your license is gone. Where does that really hit the road? Over 450,000 hours of law enforcement hours spent annually arresting, booking, processing, going to court for these individuals. It's a real resource sink for the state. Again, for folks who have traffic tickets who would not have been taken to jail in any other circumstance. So that's a quick snapshot of the problem we're dealing with. And it really is a cycle that starts with that failure to appear.
George, Tim stepped out, but
Sure.
As we remember, he had his own personal story that he shared where relocated here, if I remember correctly, he had a tag that is expired. He went online to renew it, thought it was taken care of online, and period of time later, he's sitting at a traffic light. And next thing you know, he's got guns pulled against him. He's arrested, put in a car, taken down to book and so on. And had it not been an intervention, he would have been on a bus off to a location somewhere, right?
Right.
All over something he thought had been taken care of online. So those are real life applications that frankly, it's easy for us to put them in a box and think it has to do with a certain part of a society and so on. And the reality is it can affect anyone at any time.
That's a point very well taken, Mr. Chairman. There are plenty of innocent and reasonable reasons people miss court. Even the pandemic, as we see now, because of shifting court dates and because of the risk of going in and different things that people didn't have to worry about before, there are FTAs that are happening and their licenses are being suspended. So it really is, it transcends just folks who are trying to flout the law and not show up for court. That's really a small proportion of what we're talking about here. So how do we address this problem? Big solution, pie in the sky ideas. Look at what a lot of states have done, and that is transition traffic offenses to the civil justice system. That's a big pie idea. But if we look at things, what we can do immediately, and solutions that are very small bites of the apple, but have big impact, we have a couple we'd like to share with you. First, dealing with that FTA issue of it being automatic, that courts, or when you don't show up to court, your license is automatically suspended, and the only way to get it back is showing up, fully adjudicating your case and paying your fines. The first thing we can do is we can empower courts to have some discretion in that conversation. We can empower judges to, when they have a failure to appear, to be able to choose whether or not they're suspending someone's license based on individual circumstances. And on the back end of that, allowing judges and courts to choose at what point a person gets their license back. So for one example of the real incongruity here, the law as it's written requires a license be suspended upon the failure to appear. However, the consequent, how you get it back, is not appearing. It is fully adjudicating and paying all your fines, fully resolving the case. So it's incongruent there, in addition to not having any judicial discretion. So our recommendation there, based on our conversations with judges and with folks around the state in different areas, is give the discretion to the courts to decide when to suspend and when to reinstate. That's the first piece. The second piece is, okay, what about the cost of reinstating licenses? So you probably are all aware there is a fee associated with reinstating your license, no matter how it's lost. Georgia does provide some relief for that for people who can't pay. There's a pauper's affidavit that provides, once completed and notarized, 50% off the reinstatement fee for folks who are truly indigent. What we would suggest is increasing that to 100% of the fee. That was a recommendation that came out of the Criminal Justice Reform Council when this pauper's affidavit was initially instituted. It was put into law at 50%. But we see, and I'll let the team certainly chime in here, we see individuals, particularly re-entering from the criminal justice system from incarceration, who come out with hundreds of dollars of reinstatement fees. And half off of that is just a fewer hundreds of dollars. It's still a lot of resources for someone who's coming out of incarceration, trying to get back to work. Again, the first step in many cases to getting a job is being able to drive to an interview or being able to drive to the work site. So we believe that by increasing the waivability of those reinstatement fees, it has a relatively negligible impact to the state finances, but a massive impact in getting people back to work and getting them into a tax-paying status, frankly.
George, isn't it true when we met, 2 weeks ago, we started investigating some of these numbers? We're talking about $3 million roughly. Is that right? And
that's the initial number that we've gotten. And to the chairman's point, there are good conversations already underway with the Department of Driver Services to further hone in on those numbers and understand what the true impact is. But we do believe and believe pretty firmly that it's a relatively negligible impact to the state finances, particularly when you consider the tax base that you might increase.
And to further explore that in discussions with people at that agency, we'll just say that when you have someone that possibility through the pauper's affidavit, it's reduced by 50%, it still accounts for the same amount of administrative labor on the agency's behalf. So not to put words in their mouth, but there's an indication they would rather just eliminate them total, because the amount of time that it takes to administer those, you really haven't benefited the agency. The cost is still invested there. And you're suspect whether or not you accomplished what you're trying to do, to your point, by cutting it in half. If they have inability to pay, regardless of what that amount is, they still have the inability to pay. So for the committee, there's some discussions that have already been going on with people beyond this to see what resistance we might run into to make some of those adjustments. And to this point right now, it appears they're very favorable. So,
right. Thank you. Great point. And it's a good point to emphasize that we bring these issues to you because they are statutory and they require some change in the law. But we approach, the GJP approach to policy is not only let's get reasonable common sense solutions out there, but it's also let's collaborate and let's partner with everyone who's involved. So to your point, Mr. Chairman, we were excited for the continued conversations on the executive level, as well as our conversations here at the legislative side, and then out in the community with other coalition partners as well. So we're a big tent. We want everybody under it. So that really covers driver's license ideas. Happy to pause for any questions that might be there, or we can launch right into occupational license.
So any questions about that from the committee or anyone on Zoom? They're two, honestly, pretty easy solutions if we can get support, right, from those that we're really going to impact. One is going to be more around our executive branch, right? They've got to make sure they're okay with that because that's really what's influencing our agencies. And the other is on the courts. And we've already gone out and polled some of these courts. And certainly, I don't know that there's a judge out there that has any concern about being given more power. It's when we try and restrict it that they have problems with. There may be a few out there that said, I'd rather not have to deal with this. In that case, it's their choice, right? It's a subjective matter. But giving them the opportunity to no longer be bound by statute, that it's automatic and then they have to deal with the fallout. And you already addressed this a little bit. We're seeing this in the pandemic. We have individuals that maybe were trying to get to court. In some cases, the courts were closed down. You know, if you've got a spike in COVID, they've shut the court down. The individual missed work. They fail to appear to the next one because they got their schedules already messed up and automatically their license is suspended. That becomes a death spiral for them, right? And so now they're driving to work, not knowing that they're licensed because they really didn't pay attention. Their license is suspended. Now they're arrested. And what might have been originally just a light that was out on the back of a tail light was out. Or maybe they were pulling a trailer and the lights didn't work, or who knows what that is. Some cases might be a landscaper going down the road and didn't tie off a load. In any event, we know where that goes. So these two solutions right now are already trying to be explored for the committee out there to see if we may run into resistance. But Judge, great work on that. I know on behalf of all of you and Lisa, you know, if she's on the call or not, the spearhead to push some of this forward. But I think it's meaningful change. And I'd like us to kind of discuss that. I know from the corporate standpoint, you served on that diversity council, right? And it was kind of the spearhead of that. So Doug, where do you see this may impacting with the pandemic and so on at Georgia Power?
Well, it's a huge impact. I mean, and what an incredible thing too. If you're talking about, over 100,000 licenses suspended a year, that's people that, can be taken out of the workforce. Struggling to hold on to the workforce. It's tremendous time. So I think that, we've talked about driver's license before. I think that's the low hanging fruit that you would get support on from everybody, both sides of the aisle, corporate. I don't see any pushback that you're going to get from folks. From our perspective, that's a great thing for us.
Senator Anderson, you came in a little bit late, but we went around the room, kind of introduced ourselves and so on. I'll turn it over to you. And again, we've talked about 288 that you introduced and successfully got passed, but maybe share your heart on this as well, because it's a continuation of some of the things that you worked on before we had the task force started. So.
Well, thank you, Mr. Chairman.
It's good to see you.
You too. You too. I'm usually juggling 1,000 things, and so I was late coming from a meeting that I had this morning.
Maybe we were
But-
just early.
Oh, well, you know what? I'm just so happy to be here with you all. But I think it's a great solution. These are great solutions. Because what we have to do is, as Doug said, we have to continue to put people back into society and give them the tools that they need in order to maintain just a life, just maintain their life. And it seems basic, but it means a lot. Dignity means a lot. Just the ability to not feel restricted means a lot. And so these are great solutions, and I look forward to putting our heads and hands to work to make this happen. And I think that we're moving in a direction, Mr. Chair, to expand a lot in Georgia, and the criminal justice system being reformed in a way that makes it a good balance for everyone, for our advocacy groups, for our corporate, for for legislators, and even for our executive branches. I think a lot of times the decisions want to be made, but people need to be given the tools to say, okay, yeah, now you can do it. And so, yeah, at their discretion. And so I think this is a great continuation of work that we've started and that we will continue to do. And all of the things above that I mentioned are my sentiments: life, dignity, just being able to not feel restricted to have a job. And the driver's license thing goes a long way, not just, with having it suspended for a tail light or some traffic violation, but to child support and to, all those other areas that your driver's license is tied to. So I appreciate you allowing GJP to come through and present to us and to give us, what we need as well to move our state forward.
My pleasure. Tim, you want to weigh in at all? I know I caught you in the middle of a conversation. But,
He either has his mouth full or he's a conversation.
yeah. Hoping it does not impact anyone sitting up here, but we're talking about these two solutions that we talked about on the phone.
So, I would say, yes, maybe on both of these pieces, but, I think an added element that is important for our senators who have kind of gotten the memo, that are certainly sitting in this room and more and more that are starting to see the value of these kinds of efforts is to continue to have ongoing oversight conversations with different agencies across the state. It's not uncommon, not only here in Georgia, but in the country, for legislatures to pass thoughtful measures, but they may take a while to administratively kind of matriculate across the state. And I think that's always one of my late fears on these things is that the legislature may start to express some wishes either for scope or for speed. Some of the administrating agencies might not be quite as on board on either for both of them. So it kind of takes internal vigilance to not only just pass the bill and kind of move on to what we want to revisit the 2 days and make sure that we just got to put them in the drawer somewhere. I think another piece that it's more conceptual at this point, that the technical or technological capacity of the state, I think, that's conversation. So I think that's probably worth it's the parades that kind of go down Main Street, go down Peachtree, that are calling for change are important elements to this to these kind of movements. So sometimes they're kind of dry, otherwise boring things that actually truly move the needle from a mechanical and practical level. And I do think it would be really important to have a unified technological system here in the state, because like if we talk about some of these bills, we actually have the same laws on the books, or almost exactly the same laws on the books here in Georgia now that we worked on that. So, about 3 years ago, took a while to kind of kick in, get the systems in place, et cetera. But like in Pennsylvania, we cleared over 100 million records in about the last 18 months, just because as people's kind of calendar day hits, it's a seal or expunged. Whereas here, the description that got a little bit earlier, the person has to be aware of it. The person has to find an attorney. The petition has to be held. A hearing has to be held. The petition has to be filed. A hearing held, etc. So it's a very arduous process and sometimes expensive process. Still better than nothing. Great. Automated. The problem is have so many different systems. There's about 14 counties that technologically, and so it's obviously local. So, you know, again, that's not necessarily a great kind of issue. But really, really important.
Well, we'll certainly keep that top of mind. We've been joined now by former Majority Leader and Senator from Athens area, which I know is Bulldog country, Bill Cowsert. So
Thank you for allowing me to speak just briefly, Mr. Chairman. I was in my office working on other matters today and watching you on the screen as you're being live streamed. And when you got to this driver suspension area, it just occurred to me, I wanted to share a couple of points with you, which you might include in any suggested legislation. For the better part of the last decade, the Department of Driver Services continued to put in their cleanup bills a provision to change the notice provisions to people whose licenses are suspended. And as you were just going over, the very minimal type of things that can result in a license suspension, everything from playing hooky from school if you're underage to, you know, missing a child support payment to having your insurance canceled for a brief period of time or failing to make a court appearance. The list goes on and on. It's over 17 different ways. The last I looked, you could get your license suspended. But what used to happen is you had to be notified by certified mail so you at least knew that your license had been suspended. And the Department of Driver Services, to save money, would every year put in a provision to try to allow that to just be by regular mail to your last known address, which is what's on your driver's license. Of course, as mobile as our society is, people moving and not changing their license immediately or whatever, there's an enormous number of people that get their license suspended and don't even know it until they get stopped for another offense. And then on addition to driving, whatever their infraction was, they have driving on a suspended license, et cetera. But it finally passed here. I mean, I fought that for literally for a decade. Every year it became a tucked into a housekeeping bill or whatever. You might want to consider going back. I think it costs the state roughly $1 million a year to send these certified mail notices of suspension, but just to revert to, or at least requiring them to be certified mail, it's probably worth that $1 million in the productivity that we lose from these people that you're pointing out that are not able to work, when if they had been alerted to the fact that their license was or could be suspended, they could very easily remedy that and get it reinstated by either getting up to date on child support or you know, upping their insurance if it inadvertently lapsed, or taking care of that outstanding ticket, whatever it might be. I just wanted to point that out while I had the opportunity, just so happened to be listening to you and applaud the work this committee's doing. There are a lot of ways we can help the situation.
Senator, I appreciate that. And going back to a certified letter approach is one way. Are there any other ways that you're aware of, or other states from notification that we could maybe explore as well? Do you know if?
I don't know of any other.
We all know that.
But of course, the other simple approach is to reduce the number of offenses that you can lose your license for. Make sure, I mean, that is so vital for people to provide for their families, their education, their health care, and their employment, that we ought to be cautious about taking that privilege away for minor infractions or offenses. Thank you.
Any comments for Senator Cowsert?
If I may.
Yes, sir.
Thank you. I really thank you for that presentation, sweet mate and learned Senator. One of the things that have come to my attention over and over the years, over and over again, is the fact that child support issues, which is very touchy, and because you got to support someone taking care of their family. But in this instance, for as an example, this guy was working, and they took him and put him in jail, so he could no longer actually have a job to make the payments, even if he wanted to. But so I just think there's got to be some other solution to it. And the regular mail idea appeals to me as well, because I just think we need to move along with where society is with emails and things like that. Almost everyone, they have an email, or you can text them or something like that, and get notified and ask for a response. It's crucial, the work you're doing. I'm very appreciative of it. I'm really, really appreciative of it. But the child support thing really hits home because you got a lot of economic things. Some guys don't have jobs. They don't have a job, but they still have to meet that criteria, and the judge has to do what the law says. So
Yeah.
I just wish we would take a look at that.
You
And
may
I
have hit on
appreciate
it.
what you
Yeah,
got.
you might have just hit on the solution by texting or emailing and perhaps requiring them to confirm receipt of it,
Confirm
you
receipt.
know, and let that, if they could demonstrate notice by that mechanism, perhaps be excused from the certified mail requirement if we go back there. Very good idea. there.
Yes, sir.
Thank you, Mr. Chairman.
Thank you. You know, true story about mail. We talk about the struggles of the mail. It wasn't that long ago that in my mailbox, my mail was bundled with a band, and on it, it said, "Congratulations, you have been specifically selected and that your mail is 100% certified to be accurate." Unfortunately, it was my neighbor's mail. True story. So, you know, we talk about mail being delivered. If it impacts their license and their livelihood, who knows whether they even received it. Some may choose not to, but we have a situation where they're supposedly put the extra effort to make sure it was right and it was wrong. So, all right. Back to you.
I do have something.
Yes,
else,
ma'am.
Mr. Chair. I wanted to piggyback on something that Tim mentioned. The idea of Senate Bill 288 actually came from a colleague in Pennsylvania. I was at a national conference and the representative presented it, and I thought we can do that in Georgia, just like that, up until a certain point. So we do need those systems, those technology systems, talking to each other and on one stream, one line, one corresponding course. So I don't know how we're going to work on that, but it would be great because now, you know, people do want their records or they want to take advantage of Senate Bill 288. And I thank you all so much for what you do because a lot of people come to you for that assistance. But we're going to try to figure out a way to make that happen. So Tim, I would need your ideas. We would need your ideas as to how we can make that work.
All right. Any other comments about this? All right,
I
George.
felt like one was coming. I felt like,
You
okay,
ready? You ready for me?
you've heard enough of me for a minute, so I'm going to turn it over to Wade for the next section and
All right,
talk a little
Wade.
about occupational licensing, and then we'll come back and talk about expungement a little bit more. So.
And thank you everyone for conversation around driver's licenses and your feedback. And we definitely have our long-term visions and our, what we can accomplish this year as well. And so keeping all of this in mind, both in short and long term, is extremely valuable. Moving forward to occupational licenses, our second type of license that we'll talk about today. There, as many of you may know, many jobs in this state require a license of some sort to hold that job. So about 1 in 7 workers in the state of Georgia needs an occupational license to do what they do. Of entry-level occupations in Georgia, about 40% of common entry-level positions in the state actually require a license. So when we're talking about these common entry-level jobs, that number is much greater than 1 in 7. We're talking 2 in 5 now. So we got 40% of these jobs requiring a license, and yet many boards do not have many criteria governing how they can or cannot consider a criminal record if someone is applying for that license. So while some boards are required to make some kind of determination on, is this criminal record actually relevant to the profession that we're talking about here, there's other boards who are under no such mandate. Some boards might not have to require whether this conviction was at all recent, whether it's relevant, and what this person has done in their life since a conviction or simply an arrest took place. In addition to that, we have very limited procedures that give folks rights to go through the process of obtaining a license or even having an idea of, I was just denied for the license. Why? What can I do? On top of that, we don't really have any mechanism for folks to decide whether or not they want to invest educationally with their time, with their money, into pursuing a different career. So let's say I want to become an EMT, just to pick at random occupation off of this list, do I want, I have a conviction on my background. Do I want to go to school for this? Do I want to take myself potentially partially out of the workforce to invest in myself, invest in my skills to then be able to contribute on this higher level? I don't know. So, because I might get to the end of the line and be denied for this license due to something that could have happened years ago. And so what we see every day is a chilling effect on people even pursuing these occupations, pursuing these licenses because of the opaqueness of the system, not knowing whether or not a conviction will impact them. We also see people who do go through all the investment only to come out the other end and not be able to, enjoy the fruits of their labor, to engage in that profession. So these are some of the issues that we are seeing on the ground in terms of people just getting licensed to work. And then we have some proposed solutions that really touch on each of those. So number one, I talked about some boards are required to really make a thoughtful consideration of, is this conviction related to this profession? And others are not. Well, to really underscore that, in 2016, the state passed a law that required licenses and agencies that fall under the Secretary of State to kind of make that common sense, I would say, balancing test, that weighing, is this conviction, is the age of it, is the person who's really in front of me, are they represented by this criminal record, or is this something old that's happened that's not related to this license? Boards and agencies under the Secretary of State have to make that determination. But that actually leaves 8 boards and agencies that do not have to make that determination, who are left to their own devices entirely. Those 8, that represents 41 different types of licenses. So this is a very significant number of jobs. We're talking anywhere from the healthcare field to the insurance field. So a high number of jobs where there's very, very little regulation, very little oversight into how a criminal record is being considered. And so the first suggestion here is simply, let's make that law apply to everyone. It's not mandating that anyone gives someone a license. It's simply saying, make this evaluation, think about it at least in individual circumstances. And then on top of that, to say, when you're considering whether a conviction is relevant, let's put the work of SB 288 of Senator Anderson and others, let's put that to work. Let's make that relevant here. If a offense has been expunged, then let's create a presumption that it's no longer relevant in this license, this question of whether to grant a license or not. So those are some updates that we can make to really close that loophole and also give more power to the other gains that this committee and the legislature has made on record restriction and in other areas.
And let me jump in just a quick second, Wade, because I want to mention 2 points with regard to this particular consideration. One, when we talk about the jobs that are involved here, it's quite the spectrum. I mean, it's all the way from doctors and lawyers down to EMTs to pesticide applicators to I'm trying to think of some of the others that are in that realm. Teaching assistants, nail technicians. So these are real jobs that individuals who are reentering society, who are trying to get the leg up, would be going after. So I want to flag that one piece, but also on the back end of this is just requiring a consideration. It's not forcing anyone to issue a license to anyone that has a criminal record. It's just requiring a conscious, as Wade said, a common sense assessment of how a record might impact the work that this license empowers. So I hate to jump in, but I wanted to mention that because I think it's the idea of it being a consideration rather than a requirement is important to flag.
Right. And, to the extent that different licensing agencies may say, well, what we do is extremely sensitive. Sure, that's part of the evaluation, but let's still do an individualized assessment here. Let's see if this criminal record actually has an impact here. So that's number one. Number two that you'll see here is around data collection. Right now, if you ask us about how many people with criminal records apply to name the board, name the license, how many of those are denied, what's some demographic data on these groups? We don't know. That data is not collected. So there's some pretty basic data collection that we can do to really get a better picture of who is and is not applying to different licenses to get into different professions. What are the patterns here around denials? And what can we do in the future that would make sense? Because right now, we simply do not know a lot of information that could be quite helpful to this group and others. And then finally, on that point of, I'm a person with a criminal record. Do I invest my time? Do I invest my money? Do I pursue this license? What can we do to help that person? There's a number of things that we could do. The most simple would be to simply ask the boards and agencies to provide their guidance up front, to say, here are, different states have done this in different ways. For example, in the state of Florida, agencies need to publish a list of these are all the convictions that we issued a denial over this way. We've got other states like North Carolina that say, here's our criteria that we use. It could be a combination, it could be all the above. There's many ways to do this, but let's give some guidance up front so that let's at least give people an idea. Is this an investment that I can make? Let's kind of remove that chilling effect to help people get back to work and pursue their goals. And then we can build off of that in the future. We can look at things like a binding pre-petition process of, all right, if I contact the board ahead of time, say, this is my record, as long as nothing happens in between now and me finishing my education, whatever requirements, will I be okay? These are the kinds of things that long-term could continue to evolve this work. But in the short term, a very simple solution would be, let's just have some more transparency so that people can make informed decisions, because right now they're unable to. So I think those are our basic solutions for this session, and we're very happy to hear any feedback, any questions, or things that we may have missed.
So I can see that we would have some boards because several of us in here have worked on various occupational licensing and reciprocities and so on. And you would think that we were turning our state upside down and pushing it off in the ocean during that period of time. But I can see some boards that might be very resistant to this. And some of these boards have significant influence because they don't necessarily want to put guidance in as much as have the subjectivity. I'm not saying that the boards are like this, but I could certainly see how they would think that we were in some way impeding on their power to be able to make decisions. So I'd like to open that up. Maybe I'm the only one that feels that way. So discussion around what resistance we may run into. Tanya, you're sitting there smiling behind the mask. So I know you have something to say about it.
No, sir, I don't. No, not right now.
But it'll be a struggle, I tell you that. Just as you commented earlier, I just think people, used to doing a certain thing, wielding a certain power, doing a certain procedure. The resistance change. But over a period of time, we present it in the right way, saving money, good for the economy, good for relations with the community, and that kind of et cetera, et cetera. I mean, it could be over a period of time, be some adjustments made, perhaps, I just like for the, I not keep going back to the child support thing, but it's just, for me, it's a big deal. I think it's outrageous right now that if you missed an insurance payment, that your license are automatically suspended. And you may not know the bank did it, you may have a bank draft or something. Next thing you know, you get a letter, your license has been suspended. You know nothing about it. I think we need to include that as well. It's a big, what happened? You look at your account, well, the money is there and some kind of mistake has been made or some kind of something. But it happens. Trust me, I know for a second.
Well, again, I wasn't putting this out as not worth the fight, right?
Yes.
Just, it's important, just like we talked about in the previous legislation that we talked about, is what kind of resistance we run into and then how to navigate that, right? Otherwise, you introduce a good idea and we wind up, I mean, we've seen this get shut down pretty quick. So that's why I post that out. Did you have a comment, Doug?
No, but I mean, I agree. I think this might be one of those where you're gonna have to take a couple steps at it. And so maybe asking these committees, instead of requiring them to do a certain thing around licensing, maybe you at least ask them, listen, we need to provide folks a little bit of guidance up front about, do I have a even chance to get a license before I go and invest 2 years in a technical college, or, go off and do this job rotation or something to try to position myself to get a license. Because again, we're struggling to get this workforce, and we don't want a lot of folks out there wasting time and then run into a roadblock right at the end. So I think you're gonna have to take those steps.
I think one of the ways, if we're considering things like that, we also need to study the cost associated with implementing the data collection, on these avenues, because that is it would be a mandate. So that's something we need to make sure that it's not going to be something astronomical, but at the same time, but I believe, I think we all believe in the idea, and we understand it, but we also need to understand what it's going to cost.
Right. Absolutely.
No, and to Chairman Harbison's point, the way we don't come in this with closed eyes either, that this is challenging work, and it's work that we're stepping in to talk about that people have been doing for their entire careers. So we're not coming in it with any other understanding. That we also understand that adjustments is what we're looking at. We're not looking at throwing baby out with the bathwater or upsetting the apple cart. This is all about conversations. Even the suggestions themselves are about conversations about what these records mean, conversations about what our licensing boards look like and what their work looks like, and conversations with the boards themselves about how we can collaborate. It all goes back to what we said at the outset, that there are a lot of ways to get things done, and the collaborative ways should always be the first approach. So we present these ideas with a step in that direction. How do we build that collaboration with the legislature, with the boards, and with others? So those points are all well taken, and the cost of implementing this is particularly well taken, because nothing is free. We understand that. But we do think it pays dividends down the road of who can we get into the workforce who might not have been there, or people in the workforce moving up in higher paying and better jobs that then infuse the economy with those things.
Well, I think success is going to come through collaboration.
Of course.
And I will tell you that once people start requiring things, all of a sudden that is the death knell to collaboration. So I'm just saying, be cautious of the language you use, because you want to grow the heart and the mind of collaboration with everybody at the table coming together.
Thank you very much.
Might be a great thing for a collaboration of a Department of Labor to work on that too, just saying.
It might be, honey, it might be.
I heard that.
So if there are any other questions, if there are any other questions on occupational license, I'll bring us back full circle to talk a little bit more about expungement, where we started with Senate Bill 288 2 years ago, Senator Anderson's bill, and collaboration with Representative Gaines on the House side. We know that has made a big difference. Brenda spoke to that. Rachel spoke to 105. Brenda spoke to the work that's supporting right now and what's going on. But we know there's still some challenges and still some pinch points that are causing challenges in the implementation. So Brenda, would you like to talk a little about the particular challenges here, or I'm happy to go through them. I realized you're here, so I shouldn't.
Sure, I'll get started and you can add in. Well, several of these that are listed here on your slide are sort of cleanup items. We think smaller items that hopefully we can take care of this year. One thing, like I said, the largest number of people that are impacted by this are people that have misdemeanor convictions. And there's a lengthy list of offenses that are excluded, and some of them make sense and have to do with sexual abuse or crimes against children, but there's some of them that don't. So for example, the big one here we're hoping to change is theft. If you have a theft by shoplifting or a refund fraud, you can, after 4 years, you could potentially get that restricted and sealed from your record. But if you have theft by conversion or theft by taking, in different jurisdictions, like different offenses, and charge some of the same behavior in different ways, then you can't get that off. So inevitably, every time I'm up in Cobb, I've got to tell somebody, hey, if it had been theft by shoplifting, I could get this off, but we can't. So adding that in would be helpful. And right now we have a situation where if you had a felony theft, you could get a pardon and you could potentially get it restricted and sealed, but if you had a misdemeanor theft, you can't. So that doesn't really make sense. Another cleanup item, which hopefully it'll be easy to get buy-in, SB 435, if you're familiar with that. Last year, that was something that the governor pushed around, allowing people who are survivors of human trafficking to be able to vacate their conviction or clean up their record. And there was just a little drafting oversight in there. So right now we're left with a situation where folks, if they got the record vacated, they would have to wait 2 years to be able to seal it. And I don't think that was anyone's intention. Also, a couple of smaller cleanup things, and something that I know is near and dear to Senator Anderson's heart is if you go through the pardon process, and it is an intense process that takes 9 months to a year. You have to have an interview with the board. You have to fill out this 12-page application, pretty much telling everything about your life and everything you've ever done. You're still not entitled to get your record clear, which I think you have to, again, go in front of a judge and ask for it. So we would love to make that sort of an automatic result of getting a pardon, is if it's not a serious violent felony or serious section offense, that you would be able to get that cleared. And then in the sort of growth, and as we continue to expand expungement, looking more comprehensively at felonies. There are many states that allow folks to be able to expunge felonies in a more direct way that doesn't have this year-long barrier in the middle of it of filling out the pardon application. So to go straight to the court. And there's always excluded offenses, but that would be a much quicker result for folks. And as Tim mentioned, ideally, eventually we would like to get to some place where we can implement clean slate reforms for certain offenses, because the research shows that in states where they've got a petition-based process like we do, only about 6.5% of the people that are even eligible to clear their record are ever able to do so because of the barriers to getting into court, to getting an attorney. And one thing, it's not on this list, but one thing that we had when we started out trying to advocate for this over in the House is giving some power to local jurisdictions to experiment with their own automatic remedies, because they've got their internal system, and this is happening some other places around the country. So, if Fulton County said, any marijuana possession offense that's eligible, we're just going to go ahead and automatically restrict and seal them. We could put give some power to local jurisdictions in, I think, even this year. And then the last item on here was in 2015, as part of the Council on Criminal Justice Reform, we advocated for a retroactive first offender, where if you didn't get first offender on the front end, you might be able to go back. If you weren't told that you were eligible, and you would have been a great candidate, you successfully completed your sentence. If you had had first offender, it wouldn't be a conviction, but you've got a conviction. Often defense attorneys, wouldn't even tell somebody about first offender if they had a misdemeanor, because it was this whole mindset like misdemeanors don't matter, which is not what we see every day, or that you should save it for your felony, but not everybody gets a felony. So retro first offender is great. We consider it the best way to clean up somebody's record, because then they don't have a conviction. They don't have to answer that they've been convicted. But the way that the statute was written is that before we can even get our clients into the courtroom in front of the judge for the judge to make a decision, the prosecutor has to consent to us filing. And we think there are some constitutional issues with this, but the prosecutor shouldn't be barring the doors to the courtroom door here. Sometimes just getting the prosecutor to respond, because it's not something we've been able to file yet, and getting an answer has been difficult. This is something that we have talked to the prosecuting attorneys council, and certainly would want to renew that conversation with them, but they were open to that idea and making that change.
This was prior to pandemic when you had this conversation?
Yes.
Because I would think, as we talked about, a lot of those issues that were barriers or potential barriers in the past, probably people do not see as barriers, or at least they're not as set in their ways. I mean, let's again go back to courts. So much of what we're talking about is courts, and the courts are backlogged. In some cases, they're not sure how they're ever going to get caught back up, right? So eliminating some of these things that individuals may have seen as job security. And they know that they don't necessarily need that. And it may actually work to our advantage as we try and navigate some of this. I mean, you and I've talked about this.
No, absolutely. And back to Rachel, what Rachel did actually say before about her experience with the petitions for early termination of probation. We're seeing those lag behind, and it really crosses the spectrum. So any reform, any work we can do to help either automate the process or streamline the process is well received. And as Tim said, the goal here is to get to a clean slate situation, as several states have already done, saying, after a period of time without reoffense and with rehabilitation, these records should just be clean. We can debate which records are qualifying. We can debate how long that should be. But at the end of the day, if we're really truly interested in getting the most Georgians back to work, removing the requirement to hire a lawyer is part of that. And I say that as a lawyer. It is painful, and I'll hear back when I go to the firm about sending business. But anyway, it is.
You could go to pro bono on everything and eliminate that if you're
There
really,
you go.
if you're
There you
really
go.
that convicted.
That has a whole different situation at my house. But you're right. The more we can streamline these process and clean up these process, the more folks we can get back to work. So let me just run through the quick solution, because really this is almost entirely cleanup. And to Senator Anderson's work on 288, she's also trying to do the work on the cleanup. So Senate Bill 257 is out there that handles the key 288 cleanups that we've talked about. So the bill is already hanging out there. We just need to get behind and run. It's to get behind the running back and push him through, or her through. It will be egalitarian here. So that's one piece of this. Let's get those cleanups. Then to Brenda's last point about the prosecutor approval for retroactive first offender, we enjoy a great relationship with PAC and have regular conversations with Pete Scandalakis and Robert Smith, and we keep the lines of communication open, and we enjoy working with them. So we'll be visiting with them later this week to talk more about this, but we're excited about where those conversations may have potential to go, and again, take one barrier down to getting into the courthouse door. And then finally, our reach here, obviously we want to get to clean slate eventually, but our reach sort of heading into this session is let's revisit what felonies look like when it comes to expungement. We've already acknowledged that if a felony is pardoned, that it can be eligible for restriction and sealing. That's a year-long process. Fewer than 500 of those are done a year. Let's revisit that, because remember, the restricting and sealing process from 288 still requires a judge to look at the case and decide whether this person is worthy of restriction and sealing. It provides an opportunity for prosecutors to be involved in that process. So it is a lower hurdle than going through the pardon process. So we would like to revisit that conversation of, is it time to look at that too? So those are the quick and dirty on expanding access to expungement. And that completes the 3 buckets. So we got through the buckets. We've dumped all the buckets. And I want to say, obviously, we'll want to answer questions and be a part of continued discussion. But not only thank you for the work that you've all done on 288 and 105 and the things that we worked on before, but thank you for driving this conversation. Thank you, Chairman Thompson. Thank you to the other chairman and to Senator Anderson for letting us be a part of this and really looking for solutions that help get people back to work, help get our fellow Georgians back to work. So thank you very much.
So let's park there for just a second. Let's talk about and digest what we just talked about as the 3 buckets. Then as we move into wrap up mode, I'd like to talk about, we talked about one, you evidently have a bill that's out there that's clean up, but we have some other low hanging fruit, right? And then new business that we might think about as we have our next task force meeting. One thing that comes to mind, I'll just throw out there, is we've talked a little bit about some states allow fees or penalties to be paid over a period of time. Our systems in some cases not set up to be able to do that. And some of that has to do with technology. Some of it has to do with will. Those are the 2 barriers. And so if we can, we get to the closeout of talking about what that looks like, because as we advance in technology, right, in our different agencies and or in our state, maybe statewide, to allow communication, also facilitates or eliminates some of those, whether they're realistic or imaginary barriers, right? And so we do have a certain part of the population we've talked about that doesn't have the ability to pay that $300 fee or $400 fee, but they could pay it over a period of time. And that same individual can do that in another part of our system. Doesn't seem to make a lot of sense, but anyway, so let's start. Let's talk about our buckets first. Any other comments about or questions about the buckets, so to speak? You're the one who brought the buckets.
I
up.
did. Well, it's either legs of a stool or bucket. Everyone organized.
All right, let's move into low hanging fruit then. What's executionable? We've got one, Senator Anderson, you have that that's out there. We've talked about some other things, George, and maybe we can bring that up, what you have floating that's out there. And then we've got some drafts of some other things and we can talk about that we may put out there. Obviously, we have a situation from the courts that we've talked about. There's some drafts now being done on allowing the judges to have some discretion instead of it being a mandate, right? It's codified already. Their hands are tied. If we allow our judges to have discretion in the position they sit in over the case, why would we not allow them to have the exact same discretion to decide whether or not a license is suspended? It seems to me that should be pretty easy, right? We're saying that loosely, but any questions about that? Because that thing is bubbling. We're working on that now.
Yeah, I think it's a really a good idea because give the judges discretion. As we're looking, one of the things you talk about, within law, within the courts now, or literally, needs-based assessments. And when you're looking at that, the judge needs to be able to access what's needs-based rather than just emotional-based, or rather than what's needs-based in the outcome of the court, so that they can make adjustments as needed.
Okay. The other piece that we're working on, again, we've talked about this, being respectful to the executive branch, and that has to do with the pauper's affidavit, right? We've talked to the agency, we know where they're at. They can't really speak on behalf of where they're at until we talk to the rest of the executive branch, and specifically the governor's office. But there is an openness, an appetite to see if maybe this could be eliminated. For those of us that serve in the Senate, to the general fund, we think, anyway, it's roughly $3 million, right? There's some work being done that will be provided back to us to see if that number is real. It's a little different. We've talked about this. The theme seems to be, well, we don't really gravitate as a state towards gathering information. Or maybe it's gathered and it's not reported. We're a little bit in that same posture on this issue, but best we think is it's roughly $3 million. In a grand scheme of things, $3 million is not a lot of money. It's not something that's going to impact the general fund, right? And so that is an issue that's already being worked on behind the scenes. And we're happy to bring that back to this committee again, whenever we decide to have our next meeting, to see where we can move with that. So those are two, I would say, low-hanging fruit items that have been permeating over the summer and working. So any questions about that? And then we can move to maybe some others. What other issues of low-hanging fruit do we know about? And maybe this is something that George, you can throw out. You guys, you may see it as low-hanging fruit, but us in the General Assembly may see it as a little different. Maybe higher up a tree.
Right. Well, let's back into this, starting with the expungement. First, you've already referenced Senator Anderson's 257. Supporting that and trying to get that across the line, I think, is a Senate Bill 257.
Where is that right now? Sitting in committee or?
In committee with my wonderful.
Who may be listening in.
Yes. Wonderful
Yes.
friend, Chairman Strickland.
So that is truly cleanup. I mean, it's really dealing with issues that have come up. Conceptually, we know what 288 wanted to do, and the legislature put its will behind it and passing it, the governor and signing it. This helps execute that will as it was intended. So promoting that and helping to get that across the line is important. It's something we can do immediately, since it's a bill that already exists and will be ready for action on gavel in on legislative day 1.
Well, Chairman Strickland is obviously very versed in what this impact looks like. So no, I don't want to question where his
No,
not
there
only
was-
his
there was
authority,
just-
but
Right.
what his diligence is. If he
No.
feels that that committee needs to take that up and move forward, I don't, again, I
It
don't know
was
where
a
it's at right
timing,
now.
it was a
Timing issue. Okay.
So we're going to continue conversations with them and look forward to sitting down and having a deeper one. And then to the retroactive first offender issue with prosecutorial approval. That also, we feel like is an issue that, if the legislature doesn't take a look at it, the courts may take, or are taking a look at it, it may be resolved that way. So I think taking an affirmative stance would be a relatively simple thing to do, but have a real big impact on those individuals who are seeking it.
Is there model legislation around that somewhere else, another state that we could look at?
It's literally striking a word, I think, from Georgia code. I think it may not be quite that simple, but
A line.
a line.
A line.
It's no new language that I'm
Okay.
aware of. But we can circulate that around
Okay.
too. So those are the two expungement items I think that are, I hesitate to use the low hanging fruit term, but there are things that we think have really logical and reasonable arguments behind them that would have big impacts for folks who are trying to get back.
We didn't say we could pick the fruit. We just said it's low hanging.
It is low hanging. There
We
may be
can
people with
smell it,
bats.
though. We can smell it.
There may be people with bats nearby to hit it from us, but
There you go.
yeah, that's.
But, low hanging is judgmental because for some people it's low hanging.
I'm just,
For
I'm just
some of us,
vertically
it's
challenged.
not,
Y'all
it's low
talk.
hanging at a different.
We're
height.
gonna set Chairman Payne on this because he is a little bit higher stature in reaching that fruit. So.
Thanks for bringing that to our attention.
Well, I will tell you, there's one of the things when I was in the military, we had to paint an 18-foot ceiling and I was picked to do that job. So I asked the sergeant why one time and he said, well, it's because you're the tallest. And I said, well, that means I should never do floors again, but that didn't work out.
No, that made it worse.
I'm sure you did a lot more floors. I
It made it worse.
Doug?
I'm sure I would love to get a clean slate. I mean, that would be excellent, but I'm sure Pennsylvania didn't just jump to a new system all at once. So, and I know this is going to be a hard road to go down, but is there anything we can learn from Pennsylvania or some other states about taking a step toward a consolidated system? It might be a baby step.
Well, Tim may know more about this. I mean, I think they have had a consolidated system for a long time,
have.
as do most of the, I don't know what the breakdown is in states, but a good many states, because there's good public safety reasons to have a unified court system.
Yeah, and it's Pennsylvania. Honestly, I mean, we started work on that for like 4 years ago, and there wasn't even. So it
It wasn't a barrier.
So DOJ is probably land of DOJ and probably. State you have to apply. what you actually have. Technology. They exist for this. The other piece to this that becomes a little bit of a challenge on it. Here is, always probably aware of some Pittsburgh County systems, Pittsburgh County vendors, so the procurement process, the county process, which has layers of complications. That ultimately might be your biggest. Can we do it technologically? Can we find the money to do it?
There's a question maybe for you here, especially in the vein of what you do, but coming through, again, we go back to the pandemic, right? Are we in a posture that if we don't do something that very well the courts are going to mandate, because there's been some probably discriminatory action that's happened where people did not have due process. I mean, at least as a layperson, I look at this and go, if I was in the system for whatever the vertical this was, and my life has been impacted either for a period of time or now dramatically long-term because of due process of the court systems and access, and now the pandemic, whether it's over or not over, you still can't get in the courts. I can almost see that the climate may become more of a court-driven thing where it then takes it over hands, but I'll just throw that up to you.
About backlogs that we're seeing.
I mean, yeah, we are absolutely seeing backlogs. I mean, we have clients that have been in custody for over 3 years, still pending for their cases that are still pending, that are in custody. So, I mean, and we absolutely see it, I would say, a backlog of these issues. And to Tim's point, a lack of the communication through the court systems that is prevalent through all of this. And I would say it's extremely prevalent even when you talk about driver's license. So a lot of people's driver's licenses are suspended because they're incarcerated. And we do our work out of the Metro Reentry facility. And we have a lot of returning citizens that licenses are suspended because they were in prison, but they had an outstanding traffic ticket from 7 years ago when they were in custody.
Failure to appear.
And so failure to appear. And so that goes back to that lack of communication that happens throughout our court system. And then that is prevalent from everything from, which isn't small, but everything from FTAs to people spending more time in prison and not resolving all their cases and detainers and throughout. So I think that there is, and it only has gotten worse in the pandemic. So I think it's the pandemic, which I think we've seen a lot, highlights all these other issues, right? It just really brings a spotlight to these other issues that we've already always known about, but they're just more glaring because the time is making it even longer, people being in custody, or even longer suspended license and all that stuff. So it definitely, I see exactly what you're talking about. It definitely highlights the issue. And it could, yeah, I was gonna say, it could be a situation where I think that people are going to start bringing it up on their own issues, and how does that actually affect if they're going to be in need, or is, like you said, is it going to become something that the courts are going to have to deal with?
I was just going to ask, is Justice Project, have y'all had conversations, ongoing conversations with the district attorney organ, across all 159 counties of Georgia?
Not directly. I will say that the GAP attorneys who are in the field doing direct client service are in constant contact with the prosecutor's offices where they have cases. And then from a policy standpoint, PAC is really our window into the prosecutorial world, both on the solicitor side and the DA side. So there are times when we have individual conversations, and we've had really productive ones, but our first gatekeeper is not the right term, but our first place to stop is with Pete and Robert at PAC. And we find that's a helpful place to get started.
Well, I think it would be a good thing to do is go and start that conversation with district attorneys regarding legislation moving forward, because that could be a huge help. I mean, if all of your DAs are behind it, then that makes it easy for everybody in the legislature to say yes.
Yeah, that's right. And they're particularly on 288 and 105, we had a lot of individual prosecutor conversations. I mean, between us, it's hard to get to all 159, but the ones who are particularly keyed in on both sides, be it for or against or concerned, we spend a lot of time talking to them directly. So your point's well taken, and we're always up to talk about it some more.
All right, we're going to move towards the end of the hour. We got just a few minutes left. I threw that out as a new business thing to be thinking about. We were talking about a partial payment or some type of an environment to allow people to make partial payments and things like that. Again, it's difficult in the environment we're in, but it's certainly something that other states have gone to. Technologically, we hear that might not necessarily be feasible right now, but I'll just throw that out to you.
Love the idea. And I'll turn it over to other thoughts from the team here. I think it came up when we were talking, I can't remember if it's this conversation or earlier, about what actually happens in a lot of these cases. And for folks who do show up in many circumstances for a ticket and they can't pay all the fines and fees, they get put on misdemeanor probation. And that not only carries the cost of the ticket and the fee, but a monthly maintenance fee paid to the service provider. So, that being able to spread payment out is what that does in some parts, but we need to find a way to do it without that fee component, without the probation tag to it. So does it mean just providing a resource, a payment platform that can then be adopted? Do you need to go more than that? I think there's a lot of conversations still to be had around that, but it is not a thing that would hurt the situation that we're in. And it would probably encourage, particularly for for the counties that are really feeling this crunch and want to find a way to resolve it, a way for them to easily access it. So other thoughts?
The only thing I would really have to add is part of looking at that question is that there is no shortage of options. There's no shortage of ideas and thoughts and choices that the state could make. And it's really identifying what makes the most sense for us and in what direction do we want to go. So we could have as big as transitioning to a civil process for traffic so that things like misdemeanor probation don't attach to a payment plan. You know, those are big systemic, issues that can be looked at. But then there's much smaller of, I've had a failure to appear. Let me make an installment payment. And when I do that, you release my license, where we got layers working together here for a coherent system. And then we have data that we can point to from other states that's starting to emerge to say, when we do allow for payment plans, when we do modify a debt off of somebody's income, the state actually gets more money that way. Because if I don't have money to pay my $500 ticket, if you reduce it down to $100 and let me pay $10 a month, the state's probably going to get more money that way. And so this question, I think, is a very good one, and a direction to certainly travel down. And it's really a matter of, I think, of identifying what is the process that will make the most sense for us and what we are dealing with as a state, if that makes sense.
Well, from a fiscal standpoint, you still have the administrative expense on the front end, whether they pay the fee or not. So any kind of recovery to the state offsets that expense, which then makes it more fiscal, right? Yes, we'd like to eliminate some of the offenses, but if they occur and we're applying a fee to someone and they can't pay it, we still, as a state, we're saddled with that expense administratively. So to your point, being able to recover some of that and ultimately be able to get them off of this.
And sorry, go ahead.
I was just gonna say, I'll say one other thing about it. I mean, these are all obviously great ideas, but one of the things that we are proposing is it removes the actual resolution of the traffic ticket from the suspension. So then FTA is, if you miss court, right, then all we're asking for this is the judge could then have discretion to give you back your license prior to the case being resolved, right? Like, so it's like one for one, you come back to court, which then you're no longer have the FTA. So anytime there's that's where I think it's the biggest gift. It's coming from the defense attorney, right? Like, that's where my clients missed, my client showed up, my client shouldn't have missed, or, should have never gotten the FTA. Then let's just set them back to a place where then now they can come in and resolve their case in a way that doesn't make them have to plead guilty or to resolve their case to get their license back. They're back to even footing when they come to that court.
Well, I think addressing, like we talked about with given the judge's discretion, it'll be interesting if we were successful to measure that for a year and see how many FTAs now were reduced because people weren't afraid to show up. And no, they thought if they avoided it wouldn't happen, and ultimately it happened. So there has to be a percentage of improvement that happens just by having something like that.
And you have to believe we'll see it, just in that 105,000 number. I mean, we can track that and see how it changes. But these are all tools for the toolbox. Payment plans, given judge's discretion, they're all tools in the toolbox to making it easy for people to keep their licenses and stay at work. So
I'd love to close out with a suggestion. I think it'd be great if this task force could meet one more time before we go into regular session. We have special session coming, but even if we did it during the time of November or but to bring back some of these legislative things we're talking about to prepare for January and go into session. The reality of it is we know the posture we're going into in regular session is going to be a very interesting time. I would suggest that if we have some legislation that we want to see passed, you'll have one already that is moving through the process. We make sure whether we're introducing this and get it moving through the pipeline early in January. If we don't, we're in an election year. And regardless of whether you're at where you're at on the political spectrum, we know what happens when you're in a contentious election cycle. It's very difficult for things to move or they become bartering tools. And it would be my preference that this committee identify the fact that we don't want this stuff to become bartering tools. People's lives are on the line.
That's right.
So I'm just throwing that out to say, if there's a possibility, it'd be great if we met either in November or, I hate it, but in the Christmas season, but prior to going in January. So are you open to maybe doing that? Or-
Yes. Yes.
Okay. Any parting comments? Tim, anything from you? George?
Not at all. Again, thank you for the opportunity to be a part of the process.
Sure. Any of our friends sitting up here, fellow senators, any comments?
I'd just like to
Yes,
thank you, Mr. Chairman, for bringing this forward. I think it's very important. Matter of fact, I think it's one of the most significant topics we can discuss because it impacts a lot of people. So I want to commend you for that and members of the committee.
Thank you, Ed. I appreciate that.
I would just like to say that I think that it does my heart good, to literally just being around politics, as long as we've all been around politics, to see that literally the bipartisanship when it comes to justice, matters of justice. I think that's something we always need to keep our focus, because justice is a lot higher than just politics. That's a high bar standard, justice, just that word alone. So I just appreciate all of you, Mr. Chairman, for all that we do to make sure that we're seeking that truth.
You can work with an army guy, it's all right.
Oh, wait
Yeah,
now,
well,
I
yeah.
got Army, Marines, Army Air Force, now stop all of that.
Interesting from a chairman that's around Fort Benning where the Army is. So I'd be careful.
You're right.
All right, we're adjourned. Thank you so much.
I want to say, thank you to the committee, to you,